Well, how are you?
I am fine. So that's Leah. What about Siobhan?
Hello, good afternoon.
Good afternoon. Hi, Melissa and Jessica. Someone is missing. I think they just got the link. I thought she would have been on. All right. So everyone had a good day at work?
Yes, ma'am.
Wonderful. Full of energy and ready to go.
Yeah.
All right. So then, let's start. Let me see if you can give me an idea, just briefly. Let me see how much you know about what is the company. Anybody? What is a company? What do you know about companies?
My first answer would be a company is a legal entity, I guess incorporated for a specific purpose. The thing that I always think of when I think of a company is even though it's not an actual physical person, it's separate and apart from the people that are involved in it.
Yes, good, very good. Anybody else wants to add? Be
I
shy.
would say it's owned by or ran by more than one person and has shareholders.
Yeah, some do, some don't. But no, hold on. What did you say? Ran by more than one person?
Yes.
Yeah, not all of them. Not all. Person. Anybody else wants to add? No? Okay, so let's get started and let's see if at the end of this you could answer a few questions. It won't be a test, it's just to make sure everybody understands, okay? So the first thing what I ask you all is like, what is a company? Why would someone want to incorporate a company? What is all of this fuss about having a company? Why? Well, like you said earlier, people form companies for different reasons. Some of them do it because they want to be able to donate funds to a charity. Some do it because they want to be a part of some association and they want to be able to give to that association funds. Some do it because they want to invest in a company, meaning that they don't own the company. What they actually do is they put money towards the company operating. And then they wait for dividends, depends on the type of shares that they have. Sometimes persons form a company because it may have been where the business was owned by one person and now what they want to do is they want to, I guess, obtain a capital whereby they want to grow the business. And in order to do that, a group of them come together and say, let us form a company. But you'll see when we look at the different forms of operating a business that there are advantages and there are disadvantages. So the first thing you have to realize with a company is a company has two organs. One is the shareholders and the other one is the directors. Now you see sometimes they use the word shareholders and members interchangeably. The difference is that the term members is normally left for companies that don't have shares. Normally, if they have shares, then they're called shareholders. So those are the two main organs of a company, the shareholders and then the directors. So some textbooks says that shareholders are the owners. But that word owners, it should be used loosely because it does not mean the same thing when someone owns a company by themselves. Because shareholders don't really own a company. What they do is they attend the annual general meeting and they can make a declaration for dividends. On the other hand, directors, they're the ones that manage the company. And they have that responsibility at the board meetings to look at the strategy that they have developed and decide whether or not management is operating the company in the direction in which the shareholders wish for the company to move into. So once a company is formed, it is a legal entity. It is distinct from its shareholders. It is distinct from its principals. And as a company itself, it has its own legal existence. It has its own rights and duties because it can sue and be sued. And is also separate and distinct from its members. One of the key things you always have to remember that a company as a separate legal entity is not an agent of its shareholders, nor is it an agent of its principals. So in essence, the company is an artificial legal entity, not a natural person, but it is an artificial entity. So what is all of this excitement about incorporating a company? A company has certain distinct features. And one of them is that it has perpetual succession, which means that even when the shareholders pass away or the members pass away, the company is still in existence. So if you compare that to a sole proprietorship, when that trader or that sole proprietor dies, the company dies with that person. Now they could put the business or the existence of the business itself in a will to be passed on to their children, but it's not the same as having a company. So once you have that company, if a person die or they retire or they decide to sell their shares, the company still exists. So even if a member becomes bankrupt, the company exists. Even if you ask to remove a director, the company still exists. Even if one of the shareholders decide that they no longer want to be a shareholder, they can sell their shares to the existing shareholders, or they can sell their shares to an outsider, but the company still survives. Even if a shareholder or a director has a mental incapacity or they are physically incapable of performing anymore, the company can still function. So one of the things about forming a company is that you have limited liability. It's not like a sole proprietorship whereby you are running the business and once there is a loss or you are sued, you are liable for that out of your own pocket. So once you incorporate a company, you have, the company itself has some legal roles and responsibilities. And those legal roles and responsibility, some people don't want to undertake those things. So that's when they would actually conduct their business through individuals, meaning they want to operate as a sole proprietorship or a partnership. So with the sole proprietorship, the liability of the business rests with you. And that's why you see in a lot of small businesses, what should normally be the trend is after the business has started to I guess, gain a profit, and you notice that you have a good market share, your next strategy should be to incorporate a company so that you have limited liability, so that you have succession planning. And also, in the event that something happens, the company is able to continue without having to stop for any particular reason. Now, if you look at a partnership, and a partnership normally is governed by a partnership agreement. But a partnership, again, is not a company. It's an agreement that is drawn up between two or more persons. When a partner dies, the partnership is normally dissolved. Same as if they retire or they're bankrupt. In some instances, the partnership agreement, when a partner dies, they hold their portion, their interest in the partnership is held until the probate is granted. And then the partnership agreement will normally state that the executor of the state would then, based upon what the accountant has valued the shares at, offer the shares to the existing partners. So normally when a partner dies or retire or goes bankrupt, the partnership continues. But it's always subject to the partnership agreement. The executor of the deceased partner or the trustee of the bankrupt partner are entitled to payment of their shares. And any return of capital in the partnership can affect the disruption of the business. Because then sometimes you have deferred payments. So remember, with a partnership, just like a sole proprietorship, that liability extends to the partners individually, and it also extends to their personal assets. So there's no obligation for them to register as a financial or corporate service public registry. And you know, in the Bahamas, most partnerships are law firms. But in some jurisdiction, they do have business partnerships with different features. But when you compare a sole proprietorship to a partnership, you know that that main advantage between a company and those two is that the company always survives the death of the principals or the shareholders and the ultimate beneficial owner, if there's one or two persons. So one of the main risks you would see with the sole proprietorship, and remember, sole proprietorship is a one-man business, is the risk. There's always that risk of being sued. And your liability is unlimited. And of course, the person can sue you for your personal assets. With the partnership, the creditors can actually go behind the partners individually. And partners are always liable for the actions of the other partners. Or if they all acted in the name of the partnership, then they're all liable. Versus a company is limited, their liability is limited, and their shareholders' losses cannot exceed the amount of money that they invested in the company. A retiring shareholder has to find a buyer for his shares. And sometimes you can actually have a shareholders agreement where there is a stipulation made that when a person retires, that the existing shareholders have first preference in purchasing those shares. A trustee in bankruptcy or a trustee has to find a buyer for their shares. A company can also purchase its own shares. So a company can issue more shares, and directors and shareholders can expand or downsize. But remember, as we move through the other chapters, the memo and articles govern what a company does. So no matter what happens in a company, all directions follow from the memo and arts. Because the memo and arts is the brain of the company. The articles state how the company is to be run. And where it is silent, you refer to legislation. Now, when you talk about a company with a guarantee, a member of a company, they are only liable to contribute to the company's debt to a limited extent. So while the shareholder is liable to contribute to the payment of a company's debts, he's not liable to pay them himself. A creditor cannot sue him, nor can he be compelled to pay such part of the debt as is equal to the amount of the unpaid capital in respect of his shares. Be mindful that a corporation can be a sole corporation or it can be an aggregate corporation. A sole one is where there's only one member holding a perpetual office. And you see this in the Public Trustee Act. The public trustee is a civil servant, and while in the post, they are the sole member of that corporation. So the office of the public trustee is personified as a corporation, sole, and the trust property is vested in the corporation and is not affected when there is any human changes in the company. A corporation aggregate is where there are a number of persons who in law form a single person, a registered company. A registered company is an entity that is separate from its members. Now, you could form a company under the Companies Act or under the IBC Act. And once reservation has been made and the statutory filings have been made, then the Registrar General issues a certificate of incorporation. So if I stop right there and I ask Leah, why is it so important for a sole proprietor to incorporate a company?
I would,
Leah.
I would say especially if the company becomes bigger or more lucrative, he'd want to protect his personal assets, from anything that could come out, anything that he might be liable with. Like I would always think of in terms of if he's a homeowner and he ends up going into debt for some reason, and for his company, his home is protected because he owns the home and the company doesn't.
Okay, very good. So, in the final exam, if I were to ask Lavette to state what are the advantages and disadvantage of each style of running a business, what would you say?
Good night.
Good night.
How are you all?
We're all fine, Lavette. Get to the point.
Okay, so I just jumped joined the class. So you said what would be the advantages of running a business, disadvantages and advantages?
No, you give me the advantages and disadvantages of being a sole proprietor versus a partnership versus a company.
Okay. So when it comes to a sole proprietor, I would say you kind of you have better control of what is coming in, what is coming out, how you want your business to flow, basically, because you don't really report to anybody.
Mhm.
But then when it comes to a partnership, well, that's one advantage. And then partnership advantage is also too, you have somebody who you can brainstorm with. You know, if you fall short, that person is there to help you in some way because the two of you in that together, like a team.
Mhm.
Then when it comes to, you said company?
Yes.
Okay, well, a company advantage would be where, okay, now you have more than two people working together, sharing in this common goal that the company has to build itself. So you could branch out in many different areas because you have the support from your subordinates there to help make this dream a reality based on whatever the company is. Then disadvantage for proprietorship, well, if you fall into a situation where you can't pay fees, or let's say you get bankrupt, like everything just fall on you. You have to pay off that debt. Then whereas you are in a partnership, if one person falls short, the other person have to come in and kind of help. If not, then the two of you guys in a situation. Then as a company, negative downfall, I would say disadvantage would be whereas you affecting, it would be like a domino effect if something bad was to occur, because it'll start from the top and then trickle down to the lowest person on the team. So then everybody at a disadvantage at that point. I don't know if that's the answer you wanted.
Partly. This is always on the final exam. Always.
Okay.
Always. So for homework, you have to sit down and you have to write out the advantages and disadvantages of incorporating a company, running a sole proprietorship, or running a partnership. What are the advantages and disadvantages? It doesn't require sentences. You can do it in bullet points, but you have to know the difference between the three.
Okay, thank you.
Okay? So when it's time for review, I don't want nobody looking at me like, oh my God, what? I didn't know that. Did I really need to know that? Oh, yes, you did. Okay, so at the very beginning, when you talk about a company which has a separate legal entity, it has shareholders or members, it has perpetual succession, limited liability, you know that there's a separation of ownership and management because you have shareholders and you have directors. You also know that if the company or the shareholders of the company or the directors of the company become bankrupt, or they resign, or they are removed, or they die, or they become mentally incapacitated, with a company, it still survives. So the question is, where did this whole concept of a company come from? And when you read some of the cases at the end of the chapter, you will find out that the court themselves, in the earlier times, they would go behind the company in order to sue the shareholders. But in recent times, the courts have now decided that no, this company, this separate legal entity was created for a purpose. And if we continue to go and look behind that company, we're defeating the purpose of creating this separate legal entity with limited liability. So once a company is incorporated, when it has that certificate of incorporation, then that becomes a separate legal personality. And as a company, it has its rights, it has its duties, it has its responsibilities, and there are liabilities as a company. So this whole concept of a company being a separate legal entity, having a separate legal personality, was founded in the case of Solomon versus Solomon. And in that case, the courts determined that yes, he did have a sole proprietorship. Yes, once he incorporated a company, he did put the shares in his name and his wife's name. But once that company was incorporated, it was no longer Mr. Solomon's sole proprietorship. It was a company. And there's no way the creditors could have claimed that he was trying to defraud them. Because the whole effect of incorporation makes that company that is on that piece of paper a separate legal personality. It also determines that that company is not an agent of the shareholders. So even though a company may just have one shareholder, that does not make it an agent of that shareholder. Even if that same one person owns all the shares in the company, again, it doesn't make that business an agent. And that's the distinction and what makes the incorporation of a company so unique. And that's why you will see in the business that we promote here in the Bahamas, which is the incorporation of companies, whether under the Companies Act or under the IBC Act, the Financial Corporate Service Provider, that license is used to incorporate companies on behalf of clients. So even if you have a trust company, underneath that trust company, you would have, underneath a trust, you would have companies incorporated either under the Companies Act or the IBC Act to do business, to hold assets. to invest on behalf of the trust. So in the case of Macora, a Northern Assurance Company, Macora was the owner of some timber, and he formed a company, and then he sold the timber to the company. The purchase money was paid by the issue to Macora and his nominees. No other shares were issued. Then he financed the company, and he was an unsecured creditor for £19,000. Macora effected an insurance policy on the timber in his own name. Now remember now, he had already sold the timber to the company. And not in that of the company as an agent for the company. Then a fire broke out and the timber was destroyed. Macora claimed under his policies, but he was held not to have an insurable interest. Now, in insurance law, to have an insurable interest means that he has to be the owner of that property in order to have an insurable interest. And he couldn't have an insurable interest because he had sold the timber to the company. He could only be insuring either as a creditor or as a shareholder of the company. But neither a creditor nor a shareholder has an insurable interest in an asset which the company owns. Because as established in the Solomon Principle, a company is a separate legal entity. So in that case, the judge said that it is clear that the appellant had no shareable interest in the timber described. It was not his. It belonged to the Irish Canadian sawmills of Skibbereen, Cocorg. He had no lien or security over it. And though it lay on his land by his permission, he had no responsibility to his owners for its safety. Nor was it there under any contract that enabled him to hold it for his debt. He owned almost all the shares in the company, and the company owed him a good deal of money. But neither as creditor nor as shareholder could he insure the company's assets. The debt was not exposed to fire, nor were the shares. And the fact that he was virtually the company's only creditor, while the time was its only assets, seems to me to make no difference. He stood in no legal or equitable relation to the timber at all. He had no concern in the subject insured. His relation was to the company and not to its goods. And after the fire, he was directly prejudiced by the paucity of the company's assets, not by the fire. So again, in Lee versus Lee Air Farming, here the employee, his wife, wanted to sue or sued the company for her husband's compensation. And the question that arose was whether or not he was an actual worker under the Workers' Compensation Act. Being mindful now that he was contracted by the company to do spraying in the air. But he was killed while he was piloting an aircraft during the course of topsoil dressing. So he owned the company, but he also worked for the company. And he had a contract with the company for the services that he was rendering. And the court found that he had a contractual relationship And that could only exist on the basis that there was a consensus between the two parties, between Mr. Lee and the company. And they said at the court to Mrs. Lee that she was entitled to compensation because her husband was employed by the company. And they applied the decision in Solomon versus Solomon. But there are instances where there are a group of companies. And Solomon makes a distinction, and it emphasizes that a company is distinct and is not an agent of a shareholder. And those two exceptions is where there is an agency relationship that actually exists between the company and its shareholders, and that has to be based on facts. Or where the corporate structure conceals the true facts, meaning that is just a mere facade. And once it is a mere facade, the court will disregard the separate legal entity. So a parent company is a company that owns sufficient shares in a subsidiary. I'll stop right there. Who could tell me the difference between a subsidiary and a branch? Alicia?
This isn't Alicia, but I'll take a stab at it.
Go ahead.
I think the subsidiary is a different business. So like a sister company, and a branch would be a branch off from the actual business, the parent company. Geographically, I'm thinking like a different location, maybe.
Not quite. Anybody else want to stab at it? Jessica?
Jessica's here, but I don't think I have access to the correct cost material. I think I should be in part two. So I'm just listening. Yeah.
Okay.
I'm just realizing that now because I did this before, but years ago. So I think I have the wrong manual. But so I'm just listening in to get caught up.
Okay.
Yeah. So that's my dilemma. I just realized that.
Okay.
But I'm listening.
Okay. All right.
Sorry about that. Okay. All right.
That's all right. That's all right. But you could have still answered. But that's all right. All right.
I'll take a try if I can.
Go ahead.
Is it that a subsidiary, it operates under the benefit of the parent company? Even though it's separate, it operates, it benefits from the parent company, so it's kind of like under the umbrella? Because I was thinking pretty much the same thing that Melissa said.
Agreed. I was about to say that.
Okay. All right. Agreeing. All right. So
Is it that the subsidiary, the parent company owns the subsidiary, but it's like a separate entity?
correct.
But
Yes. So a subsidiary is a separate legal entity. But the shares of that subsidiary is owned by the parent. That's what makes it a subsidiary. Because all of the shares are owned by the parent company. A branch is not a separate legal entity. It's the same as the parent. It's just an office that's being run in another jurisdiction. And a subsidiary can be in any jurisdiction also. Remember, all of the commercial banks, except the Bahamian ones, they are subsidiaries. And that's why you see everything that they do is all a part of one universal platform.
I have a question, please. I
ahead.
just, to clarify, so, subsidiary, the shares are owned by the parent company, only the parent company has shares? And if they decide to sell shares to somebody else, does that then change its status, or it's still considered a subsidiary?
Now, when you say sell its shares, depends on how many shares you're talking about.
Okay, so I guess if the parent company still has majority shares, they maintain majority control, and that keeps it that
Yes.
way then?
Yes, yes.
Okay.
So an agency relationship can arise in the context of group companies. And in that case, the parent company has to plead that the subsidiary is an agent. So it's not just, even though a company may be a subsidiary, in order for that parent company to say that a company is a subsidiary, there are certain factors that the court has identified that would help them and determine whether or not an agency relationship exists. And the court asks themselves, who was really carrying on the business? Was it a subsidiary or was it the parent? And you'll see that's why locally, the subsidiaries that are here from Canada, they have their own board. The board, the local board, is independent from the parent board. So even though a representative from the parent company may sit on the board, the composition of the board makes it independent. Next is who received the profits. You all may be a little bit too young. You may not remember earlier, way back in the 1980s, the parent used to ask for all, more or less, the majority of the profit from the subsidiaries. So when they receive the majority, it means that the subsidiary itself is not receiving the profit. And remember, with a company being a separate legal entity, the court always look at where is the mind and the control of the company. So the next one is who was actually conducting the business? Are they taking instructions from the parent? Or is it that the board and then management is making the decision that's in the best interest of that entity, that subsidiary? Then it looks at who appointed those persons. And remember, the way in which the company is run is governed by its memo and arts. And so the company itself, when it's appointing persons, must follow the memo and arts. It cannot appoint persons because the parent asks them to. They must follow the memo and arts. And then it asks who has the head, who is the head and who has the brains of the venture, which means that when you look at the minutes of the subsidiary, it should actually dictate that the company makes its own decisions. And lastly, who has effective and constant control of the business? Are they taking instructions from the parent? Or is it that management is taking instructions from the board? And so the court asks itself those same 6 questions to determine whether or not a subsidiary operates on its own or the parent is running the company. And the case that you need to read for that is Smithstone versus Birmingham Corporation, or any of the other ones, ReFG, or Firestone, or Repolypack. And of course, there's the Adams Cape Industries PLC. So, can I have, how many people I want? Can I have 2 volunteers for Saturday's class? 1 person to do Adams versus Cape. Who's volunteering? These are all online. No need to be
I'll
right.
do it.
Okay, that's Leah.
Yes, I mean, what I need to do, but I'll do it.
Well, what you're gonna do for Saturday is when you come to class, you're gonna tell us about Adams versus Cape.
Okay,
So Adams versus Cape would have been in the court again discussing whether or not there was an agency arrangement. And you're gonna explain to the class what the court decided.
okay.
Who wants to do Repolypack? Melissa?
Sure.
Okay. Because I think Saturday class is in person, correct?
No,
Yes,
am I
ma'am.
on Zoom?
What? What's that mumbling I hear?
They said yes.
Oh, okay. Because I know that,
Really?
yes?
Yes, they said Saturday is not optional. Thursdays is Zoom and Saturdays are strictly face-to-face.
Oh, I didn't get that memo either, but
No,
okay.
they told me everything is on Zoom.
Well, I asked no longer than today, and they said Saturday is face-to-face, so I don't know.
Yeah,
Every Saturday is face-to-face?
Yeah, Saturday's face to face. They told me that the other day as well. So that's confirmed.
Wow.
Who's saying well? That's Janice?
No, I said, wow. Because
Oh,
when I
wow.
signed up, they told me everything would be on Zoom.
Oh. So you can't make it on Saturday?
Not all of my Saturdays I could make it.
Okay, so on the ones that you can make it, then you just let Miss Dan know. And so
So
see
they
how,
wouldn't be doing it and they wouldn't be doing it. The option for Zoom still will not be available?
I don't know, that's what I'm saying now. You speak with Miss Dan.
Okay.
Yeah. Stress not. All right. So remember I told you all earlier that sometimes the court would go behind that the whole concept of a company when they're of the view that the principles of the company are trying to defraud or it's just a mere facade. And they call that either lifting the corporate veil or piercing the corporate veil. And there are certain cases where the courts have actually pierced the corporate veil. I'll assign some cases at the end. So normally, when you're talking about piercing the corporate veil, the court says that in today's cases, they're saying that that is something that the court should just not go ahead and just pierce the corporate veil, because it defeats the purpose of having a company. You all have access to the internet now? You net or computer?
Yes, I do.
Okay, look up the case of Press versus Petrodel Resources. Now that's a very good case to read. And one of you will present that case on Saturday, because it really shows how the courts, instead of piercing the corporate veil, they found another way to address the issue. So in this case, let me see, when you pull it up, Press versus Petrodel, select the one that says Supreme Court. And you do the Google search. And then when you see Supreme Court, you see judgment PDF. And you can click that one. And this case may appear to be long, but you have tonight and you have tomorrow to read it. Because in this case, it's going to mention a lot of the other cases where the court would have pierced the corporate veil in the past. And the judges are telling you why they're not doing it in this case. Because they said the piercing the veil is reserved for instances where the court does indeed ignore the separate personality of the company. And they look behind the veil to the members. So they say courts use their discretion to pierce the corporate veil. That is to ignore the Solomon principle. And they do that when it's justified on public grounds. And in this case, you'll see what the court said was they didn't pierce the corporate veil. Because this was a matrimonial matter, they actually decided to use trust principles rather than piercing the corporate veil. So I know it looks long, but it actually encapsulates everything that you need to know about piercing the corporate veil. And it also goes through all of the leading cases where the courts would have pierced the corporate veil in the past. Now, who's volunteering for that one? Press versus Petrodel.
Yes, I can try.
Ah, I know it was you. Your name is already there.
Oh, Lord.
Okay. So when you read this case, you're gonna see they're gonna talk about other cases, and they're also going to mention Cape versus Adams. But Leah will present her Cape versus Adam before you. So lifting the corporate veil is a concept where the rights and the duties of a company are in principle the responsibilities of the company. And they become the rights and the duties of the shareholders. That's what piercing the corporate veil is. You move the responsibility from the company and you then put it on the shoulders of the shareholders. And this is normally done in certain situations where a company is insolvent or where there are creditors who are not paid and they want to recover their money. And so then they involve the shareholders in the matter. So the corporate veil has been pierced where there was a single economic unit, Adams versus Cape, or where there's an agency principle, which was Smith versus Birmingham, where there was an evasion of limitations, and that's Jones versus Lipman and Guilford Motor Company. Who wants to do Jones?
I'll do it.
That's Janice?
Yes.
Okay. Jones versus Lipman, and then someone to do Guilford Motor. Who missing? Deandra?
Yes, ma'am, I can do it.
Okay. Guilford. And even in the recent case of Conway versus Rattouille, who wants to do Conway versus Rattouille? One person left. No, two persons left. Who wants to do Conway? No volunteers? Siobhan? No? Siobhan,
can
you,
do-
you
I
do
can do
it? Okay,
Yeah.
Con- So in that case, the Lord Justice said the readiness of the courts, regardless of the precise issue involved, to draw back the corporate veil to do justice when common sense and reality demands it. So the cases demonstrate where the members are made liable and can be explained on orthodox legal principles. Members' acts constitute them as principles of the company, and the company is an agent. Beneficiaries and the company is the trustee of the corporate assets for their benefit, or constructive trustees or dishonored assistant in wrongs committed by the company. But be mindful that third parties can only sue the directors when one of the agency or trust arguments can be advanced. It's difficult for third parties to sue the company's directors for liabilities of the company's unfulfilled obligations. Third parties must sue the company. Also note that the director's liability is not limited as the members. Directors have a duty of care to the company, and the company can sue the directors for any wrongs that they have committed against the company. To be mindful of that. That directors, they have a duty of care, and that duty of care is in law. So when you look in the Companies Act or the IBC Act, it states that the directors have a duty of care, but it doesn't spell out what that duty of care is. But we will actually go through that duty of care. And so,
Yes,
go ahead.
Audra.
Mhm.
I don't know if this would relate to the same thing, but when there's an owner, right, and now they have a company, when the board of directors or whoever, they would decide to say, okay, we're going to let this person go. How does that work?
What you mean? Say it again.
Okay, I don't know if y'all ever watched Supergirl, right?
Who? No,
Supergirl.
no. Go ahead, explain it again.
So she owns a media company, right? The lady owns a media company. She's the head of the media company, but the board of directors decided that they're going to have a meeting to see if they would let her go based off of information that was leaked and it was reputational risk for the company. How does that work if you're
Stop
the
right there.
owner of the company?
Stop right there. Stop right there. You say
Mhm.
she's owner of the company, so you're telling me that
Mhm.
she's a shareholder.
Right. So she started the company. This is her business, and then she went big time. So now it's incorporated. And so now you have a board,
Oh, no, using different
right?
language.
It's-
Confusing.
That's different.
No, you're confusing me with the terminology. Okay.
Maybe
gonna-
I heard it wrong.
I'm gonna say it and then you tell me.
Okay.
She is either two ways. She had incorporated a company where she was the sole shareholder and the sole director. And then she opened up her company to get more capital to expand. And she invited other persons to be shareholders in her company. Is that what she did?
Let me hear the next option.
The next option is that she is a sole proprietor and she runs the company.
No, it's the
Back up.
first. Mhm.
Okay. So she has a company And then she decided to invite other persons to invest in her company, correct?
Mm-hmm.
Okay. So let's call her company Supergirl, whatever you want to call it. And she invited other persons, but she still has the majority of shares, correct?
I'm not sure, you know, but it was several TV shows that I watched where the owner, the first person that started the company, or it was originally their company, was fired, and I always wondered how that would work.
No.
Like,
see,
how is
no,
that possible to be fired?
okay. So if I've never watched it, but let's just say she owns the company, right? So she owns it. She is the shareholder. Underneath the shareholder is the board of directors.
Mm-hmm.
If it is a 1-man or 2-man company in terms of shareholding, one of those shareholders can actually sit on the board. Okay? So she could be the shareholder and she also can be a director.
Mm-hmm.
Because she owns the company herself and she owns the majority shares, she may decide that she wants to be the CEO or the managing director so that she can dictate how she wants the company to run.
Mm-hmm.
And in that instance, the board of directors can fire her.
Oh, okay.
Yeah.
Can I have, I just want a follow-up question to that. In a case like that, could it be that she's now trying to make the company not really exist as a company? Because she still wants to maintain control of everything through her, I guess, her directorship or whatever the main role would be.
That would only come about if it is found that she's doing things that are contrary, which means that as a director, she's not acting in the best interest of the company.
Okay.
You see, because a person can play these 3 roles and play them separately and not exert exponential control over the company. It can happen where they act like a normal CEO, where they wait for instructions from the board. Because then it comes again, just like you're saying, it comes to how much control she has over this company. Now, we have companies in the Bahamas incorporated under the IBC Act. So the IBC Act says that they can have 1 shareholder, they can have 1 director, they can be one and the same. So they direct everything themselves. That's the beauty of that creature. But it doesn't work like that under a Companies Act company. So the first thing you always ask yourself when you see a company is, what type of company is it? 1, and 2, where was that company incorporated? Because each jurisdiction has its own legislation. At each jurisdiction, when you incorporate a company, depends on the purpose for which it was intended, has a different way of it being set up. Any more questions on that? Don't be quiet. If you have questions, ask. No questions is a silly question. Or you could write it down until after you read your cases, and then you could ask on Saturday. But don't be afraid to ask the questions.
I'm sure I will have plenty questions, but to be honest, I think I need to read the chapter myself
Yeah.
and like make my little notes first, and then because it's a lot. And some things I didn't know, so I think I would have to go over it myself for me to understand it from my view, and then I could probably ask some questions later.
That's fine, that's fine. I'm trying to remember if there are any other cases, anything else. Maybe you could watch on Netflix. Doesn't Netflix have that movie, The Laundromat? I think
I've never
so.
heard of it.
Yeah,
What's
there's
that? Money laundering?
the Laundromat. That's a movie. It's a movie on company. What else? I mean, we don't even have to go that far. We could just look at the recent news in the papers. The matter that's before the courts now. The one that's always in the paper.
FTX.
Yes.
Mhm.
That's another one. How do you think that operated? Just from reading the papers. Company law now. How do you think that operated?
I don't think they were following the legal liabilities that the company needed to follow. That would have protected everything that's going into the company. So it was a fraud, in my opinion.
So what
So
people do?
the
Go ahead.
memo and art.
Go ahead.
Would that what Leah said would sum up to the memo and art? Like the structure of how the company was supposed to run. So basically he was doing the opposite of what the intent was, or using the
Well,
funds in a different way.
I was coming
Um,
more from a regulatory standpoint, having controls in place that you could monitor and you could report on and that kind of thing.
Mm.
there are two key things in company law, overarching things that should always be in your mind if you I guess if your whole let me see, if your area of concentration in your job is around incorporation of companies and maintenance of companies, or if you are a corporate secretary of a company, there's two key things you have to remember. Two key terms: corporate finance and corporate governance. They go hand in hand with company law. Corporate finance is how a company raises money and the laws that go with that. And then you have corporate governance, which is how to run a company. And the legislation and the regulations and the guidelines that go with that. Company law needs those two arms: corporate finance and corporate governance. So when you look at that entity was structured first with a group of entities. So if you look at it from a regulatory standpoint, the first picture that's supposed to come to your mind is how many of those entities were under the supervision of the local regulator. And this is not just by structure, meaning by ownership, but you also have to see how the money moved between the entities. Because that makes the determination of what? Who has mind and control? Who's actually operating that company? Is it just an agency within the group? You all went silent. You want me to leave that until until Saturday when I draw it on the board?
Yes.
Yeah, I
Yeah.
want to read
Listening though.
some more.
Yeah.
Please
Trying to understand.
Okay. I'll leave, just remind me and put it in my note here. Without calling any names of any companies. I will try to explain to you how it works. Okay, so as a separate legal entity under the Solomon Principle, a company has liabilities. And you can see that in this same issue we're talking about now, that's always in the paper. They have contractual obligations. And this is where they're at now, looking at various contracts. Who owes who and who's going to pay who? Who is the contract with? The parties in the contract says A and B, but who is actually doing the arrangement? Where were the funds going? So now that's why you see there's an argument in the papers saying whether or not it's here or is it there. And they've ring fenced what they say is theirs. Because everything is based on where the companies were incorporated. Because that's the law that governs those entities. But again, like I said, it's where is mind and management. So if you had an agreement with a company that was incorporated here versus someone that has an agreement with a company that's incorporated in New York or one that was incorporated in Australia, the question is, who are the parties to enforce the contract? And remember, under contract law, only the parties who have actually signed the contract are the ones that can enforce it. That's the first thing. The second thing is you have to be sure that the persons who signed the contract had the capacity to do that. Not every officer or agent of a company have the authority to enter into certain businesses or certain transaction. Certain transaction or certain level of transaction require the approval of the board. And certain transaction, when it comes to the board, may require the approval of the shareholders. Now, a shareholder cannot enforce a contract made by the company. Always remember that. Why is that? Why can't a shareholder enforce a contract made by the company?
Because the contract is made with the company and not the shareholder.
Exactly. He is not a party to that contract. He's not entitled to any benefit of that contract. The benefit is for the company. So in that same light, the shareholder cannot be sued on contracts for the company. Because really the only thing he's waiting on is dividends. Nor a court could compel a shareholder to vote at a general meeting to ensure that the company will fulfill its contractual obligations. Only the parties to the contract can bring a matter to court to sue. Now, the second thing, as a separate legal entity, a company can bring matters under tort, just like you and I can bring matters under tort. If someone is encroaching on your property, you could bring a matter under tort in court. If someone is growing their big almond tree and the almond tree has now grown over into your yard and dropping almonds in your yard, dirtying up the place, you told the person to cut down the limb, they refused to. you can go to court and say that this person is creating a nuisance, or you have a neighbor who always blasting loud music. You can go to court for tort. The same thing a company can sue in tort. And it also can be sued for tort. And any suit that is brought for tort, it is done through the company's agents, which means it comes through the directors and the employees. And always remember, when you see that sign on the back of the car, that if you see this car being driven carelessly, to call this number, that is because the company is liable for the acts of its agents. And they have to be acting during the course of the employment, or whatever it is that they're doing has to be within the scope of their authority. So always remember that. Someone coming and say they're acting on behalf of ABC company, you have to find out whether or not that person has the authority to act in that capacity on behalf of the company. Also, you could have liability of what we call a joint tortfeasor, which means that a company can be liable, a director can be liable with the company. And that happens when the director authorized a wrongful act. But if that director is carrying out an act in accordance with the articles and the memorandum of association, then he will not be liable as a joint tortfeasor. Then you could have liability of a director for tort committed by him. There are instances where a director himself can be liable. And that is whether he is a director or not. And when you read the little short summary I have in here on the Standard Chartered Bank versus Pakistan National Shipping Corp, you will see where the director himself was liable. So in here it says, he was the only human involved in making the representation of the bank. The managing director in this case was being sued not for the company's tort, but for his own tort. He was not liable because he was a director, but because he had committed a fraud. So a director may also be liable for the negligent misstatements if there is an assumption of responsibility and reliance on that assumption. Because in this instance, he made an assumption. And last but not least, a company is also subject to criminal law, just like you and I. So a company can be found guilty vicariously. So that's when its employee, during the act of employment, on the scope of the authority, commits an offense, the employer then becomes vicariously liable. And sometimes, in certain cases, the company can still be liable, even though that employee was forbidden from behaving in a certain manner. The court can still find that the company is vicariously liable, because there are certain offenses in criminal law that have strict liability. And in most instances, the court always looks at who had the directing mind and will. So remember that in company law, even though it is a company, it is a separate legal entity, just like a person. The court looks at who has the directing mind and will. Who is running this company?
So Ms. Archer,
Yes.
let me just use the banking as an example. Is
Mhm.
that where the bank would say, okay, we have to follow certain regulations, for example, AML, ATF, and even though the employee is the one that did the transaction, and it was not picked up by audit, let's just say that, like it was not picked up, the staff did it, the employee did it, management didn't pick it up, and then audit didn't pick it up, and now the bank would be fined. Is that an example of what you're talking about?
Mm-hmm.
Okay.
Yep. But of course, on the end of that, once they do their investigation, the employee dismissed.
Would be most likely be terminated.
Mhm. Yeah. So it happens. Someone doesn't have a case. Is that Jessica?
That is Jessica without a book and without a case. That's
Don't worry
me.
about that. Don't worry about that.
What is my case?
Let me find one for you. Let me give you one. Let's see.
Mm-hmm.
There's plenty in here, plenty in here. I'm just trying to find one.
Okay.
Failed. See if you can find Meridian Global,
Okay.
the one under criminal law.
Okay.
Yeah, let's do Meridian Global Funds. Versus security.
Okay.
So everybody has one, except Alicia. Alicia, you say you're just sitting in, right?
I think that was just Jessica sitting in, but you still gave me one, so.
Okay.
But so that's Meridian Global Funds versus
Securities.
securities. Okay.
So it's Alicia that needs one now. Last but not least. She's very quiet. I don't know.
Sent a message earlier to say that her mic isn't working.
Okay.
Listening.
Okay. All right. Let me see if I could find one for her. Let me let her do one. I don't want to give her that German one. That's a little bit too convoluted. Fine. She could do Standard Chartered. Standard Chartered Bank, Pakistan.
Okay, I see it.
Yeah.
And we're basically summarizing these cases to explain in class.
Yes.
That's the assignment? Okay.
Yeah. Yes, we are. Some of them were where they pierced the corporate veil. Pest versus Petrodel, which is the latest one, is where the courts said that they're not piercing the corporate veil. You're going behind the whole principle of creating this whole concept of a company. And so the judges said that no, they're not doing that. So that'll be the Pest versus Petrodel. And we'll do Standard and Meridian, some of the last ones. Standard and Meridian. And the rest could follow afterwards. All right, so those who didn't have a chance to read can read. You have your cases. We'll have a quick chat about the item that's in the newspaper. You get a concept about companies, subsidiaries, how it operates, looking at mind and management and who has control. And then you'll get an idea of why there is so much back and forth. Why is this such a big problem? And things are just heating up now. Okay? Everybody has an opportunity to read. And I will see you all on Saturday.
And that's 9:30?
On the dot.
Okay.
I have a class at 12:30, so I have to leave on time for my next class.
So the class is 9:30 to 12:30 or 9:30 to 12?
9:30 to 12 or just before 12, depends on how studious you are.
Okay then.
Now, other lecturers may probably keep you all there until 12 and 12:30.
What time is that we stopping at on Saturday?
Oh, we start at 9:30, 10:30, 11:30. By 11:30, 1:45, we're done.
Sounds good.
Mhm. Yeah, the longest part will be the presentation.
Okay.
Unit, any questions that you have, then we do unit 2. So we'll go from there. All right, so if everybody's on time, 9:30 we start.
Okay.
All right.
Okay, good night.
Good night. Good
Good
night.
night,
Good
everyone.
night.
Good night.
Okay, good night.
Okay, what is it? Company law 1. Got this.